Hello everyone, my name is Hizam and today I am going to represent my team on presenting about contributory negligence. However, before I can get deeper into contributory negligence, first of all I have to explain to you guys about negligence and also law of tort. First of all, I will explain about law of tort. What is law of tort? Well, the word tort itself means wrong in French, and the culprit is called the tortfeasor. What does the law of tort do? Well, the law of tort protects us from people, finances, property, and reputation. Law of tort is used to determine when a person must pay compensation for damage caused by a mistake. It is also used to determine what actions can be deterred or regulated by a court order. Next, I will explain about negligence. What is negligence? Negligence is a separate tort. What is defined by negligence? Negligence is defined as a breach of the legal duty to take care whereby the plaintiff suffered damage. There are three elements of negligence that must be proven in order to succeed in an action for negligence. The first one is duty to take care. The next element is breach of the duty. And lastly, the element that must be proven is the breach causes the injury to the plaintiff. Now, after you guys know about what is negligence and also law of tort, I can finally explain about what is contributory negligence. Negligence comes in many forms. One of them is contributory negligence. Contributory negligence happens when the plaintiff fails to take care of himself properly along with the defendant's negligence, which then causes his injury. Contributory negligence, however, is a partial defense, whereby the defendant who must plead for contributory negligence. As a result of contributory negligence, the damages will be reduced based on the plaintiff's share in the cause of damage. Now, there is a law that relates to contributory negligence, which is Section 12(1) of the Civil Law Act 1956. The law said that if a person suffers damage partly through his own fault and partly through the fault of one or more other persons, a claim for that damage is not due to the fault of the victim, but the damages recoverable in this respect will be reduced to the extent that the court deems fair and equitable, taking into account the plaintiff's share of liability for damages. Here is an example of case that relates to contributory negligence, which is the case between Ramachandran anak lelaki Mayandi versus Abdul Rahman bin Ambo. Here is a short explanation about the case where the plaintiff was reportedly to suffer accidental injury while employed by the second defendant. Another employee of the second defendant told him to open the trailer's door when it flew open and some of the iron bars rolled down and hit him, which ends up injuring him. Now, you guys must be curious on how does that case relates to the legal principle. Well, the plaintiff did not pay sufficient attention to his own safety. In this case, the judge identified three specific acts and omissions of the plaintiff. The first one is that the plaintiff failed to maintain a safe distance when removing trailer door bolts. The second one is that he didn't expect anything to stop the iron bars from rolling down as soon as the door opened. And lastly, he did not assess the risk carefully, even though he knew his actions would pose a danger. As a result, the plaintiff is charged with contributory negligence. That's all from me. Thanks for watching. I hope that you guys can learn a lot of new things by watching our videos. See you soon!